just as Professor Sengupta did, I'm going to put women first. When I was writing women's history back in the day, we decided to use phrases like women and men, wives and husbands, queens and kings. And the fact that those phrases are still not current, I think signals that we have a fair way to go. Now, I'm old enough to remember having witnessed an illegal abortion, so I would like to describe that to you. A very close friend of mine named Enid got pregnant just after we graduated from college in 1965. So abortion was illegal. We were privileged. We were white, we were solidly middle class, and we lived in New York City, which meant we had a lot of contacts. We talked to everybody we knew, and we found an MD for her, which was really good. He asked us to come to his office at 5 in the morning, and he charged $900 for the procedure, which the equivalent today is $7,300. We got there, and he performed what was called a D&C, dilation and curettage, dilating the opening of the uterus and then using a curette, which is shaped like a spoon with a sharp edge, to pass over the surface of the womb to remove any fertilized egg or fetus. He did this without anesthesia, which was never done. And my friend came out bleeding and screaming, and fortunately was okay. She borrowed $300 from me. She had $300, the guy had $300. It took her years to pay it back. That was the best case when abortion was illegal. Most women didn't have those privileges. And the Supreme Court never examined the worst cases. Women who would, use a coat hanger. Most young people don't know why the coat hanger is a symbol of the, pro-abortion movement. It's because women would straighten out the bend of the hook of the coat hanger, shove it up themselves, hoping to pierce their uterus so they could deflect the pregnancy. Other people went to quacks, attempted falls, or took poison. By the 1940s, over 1,000 American women died each year from illegal abortion. And hospitals created what were called septic abortion wards to reduce the number. By 1972, the last year when abortion was illegal in this country, 39 women died out of 130,000 who attempted to end their pregnancies. Outlawing abortion does not stop women from trying to abort pregnancies. It just makes it unsafe, dangerous, and sometimes fatal. None of these facts is mentioned or even alluded to by the Supreme Court, nor is the fact that 60% of Americans believe abortion should be legal, and 30% of anti-abortionists believe it should be legal in some instances like rape or incest. As a woman I like to follow, Heather Cox Richardson has often written, turning such legislation over to the states is exactly what the Confederacy tried to do. And if you turn it over to the states, you get the situations we've read about in recent months, where a 10-year-old is pregnant and can't get an abortion, where a 14-year-old is asked by a doctor or told by a doctor she's not old enough to decide to get an abortion, but she is old enough to be a mother. Terrible situations. Instead, the Supreme Court asserted, quote, originalism, insisting that a topic must be in the Constitution to be upheld. I think this argument is ludicrous, and I am not alone in this. This is exactly what the American Historical Association and the Organization of American Historians, which Professor Sengupta alluded to, argued. Women are not mentioned in the Constitution. Do we not exist? Slavery did exist when the Constitution was written, and in fact, the so-called Great Compromise, which allowed slavery, never used the word because they were ashamed of it. They called slaves all other persons. Enough of the brilliance of the founding fathers, in my and others' opinion, was to acknowledge that they did not know what the future would bring. They put the power to amend in the Constitution, only limiting it to not creating a new monarchy. Article 9 of the Bill of Rights, without which the Constitution would not have been ratified, states, quote, "The enumerations in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." This seems pretty clear to me, but not to the conservative justices who spent a great deal of time arguing that the right to privacy, the basis of Roe, is not mentioned in the Constitution. They also argued that what they were doing was not political. Now, because of the small view, you can't really see my earrings, but they're Ruth Bader Ginsburg's collars. And that's in honor of her, because as long as she was on the court, no one, you know, she had the fifth vote for not overturning a bill like Roe. But the new Supreme Court, with 3 justices appointed by President Trump, argued that they argued against a very old legal principle called stare decisis. Stare decisis literally means to stand by things decided. And it's that except in very extreme cases, a court should not rule against legal precedent. This court argued speciously that they were not overturning that doctrine, but, quote, reinterpreting it. They compared their ruling to Brown v. Board of Education, which overturned the late 19th century ruling of Plessy v. Ferguson upholding segregation. But there are crucial differences in the 2 rulings. First, Brown was a unanimous court vote, 9-0. Second, Brown expanded civil liberties, while Dodd curtails them. In addition, since we're looking into historical truths, Justices Alito, Gorsuch, Kavanaugh, and Barrett swore to uphold Roe in their senatorial hearings. Mentioning Barrett, I cannot help but think of Kate McKinnon's parody of her on Saturday Night Live. Justice Barrett said that if women didn't want to have children, they should give birth and then give the babies up for adoption. And McKinnon said, just pop them out and give them away. So these are the things the justices did not say. What did they say? Judge Alito cited Matthew Hale as an authority in his opinion. Hale was a 17th century English jurist who was considered a misogynist in his own day. He did argue against all abortions, although the word was not used then. And as Professor Sengupta said, before quickening, you know, a mother could do anything she wanted. He also argued that women could be burned as witches and that marital rape did not exist. Some authority. Justice Thomas, in his decision, went even further. In his opinion, which argued that stare decisis did not exist in this case, he also argued that the court should rule against same-sex marriage and even against contraception. He did not rule against interracial marriage, which of course was also illegal in those days because he is a Black man married to a white woman. What a hypocrite. Given the state of the Supreme Court, and remember that the justices voting to overturn Roe were nominated by presidents who did not win the popular vote, there are a number of remedies. First, and this seems extreme, enlarge the court. And here I want to cite the example of FDR, Franklin Delano Roosevelt. When he was president, trying to implement the New Deal to solve the Great Depression of the 1930s, the Supreme Court kept voting down his measures. And he threatened to enlarge the court from 9 to 13 justices. There is nothing in the Constitution that says how many justices should sit on the Supreme Court. The threat worked. They caved once he had threatened to enlarge it. I'm interested to see what should be happening today, and I've been signing many petitions to enlarge the court if necessary. More importantly, the Supreme Court does not have final say in this nation. Congress does. Congress can pass laws overruling the court and has done so many times, most particularly in the post-Civil War era, right? But in order for this to happen, Democrats must win. So my final words to you are get out and vote. I'm encouraged by the fact that so many young women have registered to vote, more than in any other period. and by the pro-abortion vote this summer in Kansas, which is not a blue state. So I'm going to end by saying, row, row, row the vote. Thank you.
Could I follow up, if I may, just this question could be directed at all the panelists, but Bonnie in particular, given that much of your scholarship has dealt with the history of activism, what advice would you have now for young activists, in addition to the imperative to vote? But beyond that, especially in Pat too, given your both of your backgrounds and perspectives and scholarship and activism?
I would say canvas. I mean, canvassing is really important. I canvassed for Obama in Pennsylvania. I'm not able to do it now because of my age, but young people can certainly go to non-blue states and go door to door. And that's a very effective strategy, particularly if you respect the other person, you know, and say, how do you feel about this? And talk about feelings. And it's very powerful. The other method that is less possible for young people is to donate money. And that's good for older and middle-aged people.